Neama, let me start with you if I could. I would love your overall thoughts about how the first witness went in terms of the direct and the cross.
Actually, the first witness is always critical for the prosecution. You want to come out strong. And it's interesting that they chose Dominic Black, someone that was friendly with defendant Kyle Rittenhouse. But I think the prosecution did a very good job scoring some key points. I know they want to present this case chronologically, and that's why they went with Black in this particular case. But I like the fact that they got out that even though individuals were throwing rocks at Dominic Black, he didn't use deadly force. I like the statements that he made, that his family was encouraging him to flee. And the fact that he too has been charged with felonies, and the defense tried to cross-examine him and trip him up a bit, but we saw that ultimately that prosecution trick, you always want to tell these witnesses that are subject to cross-examination based on cooperation that they should tell the truth. That's the most important thing. So the defense fell into that prosecution trap that was laid out nicely. I thought it was a very good witness for the prosecution because he showed, even though that he was friends with Rittenhouse, that deadly force wasn't appropriate in this case.
Might be thinking or might not be thinking, if anything, about Kyle Rittenhouse's behaviors, the yawning, talking to his attorney, and a little animated at times.
Yeah, what Chanley said is spot on. The last thing you want if you're a criminal defense attorney in a murder case in which you're arguing self-defense is your client to be yawning, for there to be a perception that he is not taking the proceedings seriously or doesn't think that this loss of life is something that's important. And let's not forget, I mean, the jurors are all human beings. They've probably heard about Kyle Rittenhouse's episode at the bar or association even loosely with white supremacist groups and different signs that he may have made. So if you are his defense attorney, you need to counsel him that this type of behavior is not helpful. Conversely, as we've noticed, Ashley, we've talked about this at length, having that family support in the courtroom and the gallery is important. That's something that jurors pick up on. So that's something that will be helpful for his defense in his case.
I must ask this. A lot of people had talked about, what about where he got the gun? Why aren't they being held responsible? How did this 17-year-old get a gun? Well, now we know, and we know what that scenario is. Is that something that you think in and of itself is important for the jury to hear?
It is, and Chanley and I think alike, but I love what the prosecution did here, because whenever you have a cooperator, as we call them, or a snitch, as the defense calls them, you want to get out ahead of that testimony, and that's exactly what the state did here. Brought that up during direct. You don't wait for cross-examination for the defense attorney to get into all that, even though they tried to. One other key point of Black's testimony is Rittenhouse's own statements. He did say that he defended himself, but he didn't say that he was concerned about a gun or a knife or Rosenbaum trying to get his gun from him, because we know that's going to be important. And he is by far the most important victim, not because of his life being more important, because of the chronology of events and the state arguing that he was only armed with a plastic bag. And that federal surveillance we're going to hear from, because we know the state previewed it during opening statements, that Rittenhouse was actually chasing Rosenbaum and not the other way around. So the fact that the state got into this testimony and Rittenhouse's own statements was very effective as well.
Neama, from a former prosecutor standpoint, what might the reason be that there's no pictures or video of the next witness?
Well, maybe that the victim is a minor one. In this case, probably not, because we're talking about 2008 arrests and convictions. Unlikely in this case. Sometimes judges will honor the request of a particular witness not to be videotaped or audio recorded. That's what I think is happening here. The judge is simply accommodating a unique request of a witness. And we know that this particular judge plays by his own rules, so I'm not surprised at that ruling in any respect.
Right, and I do believe, as to my recollection, as this judge did indicate, that was something he would take into account if, in fact, there was a witness who did indicate they did not want to be on audio or have any pictures of them. They see what happens in the prosecution's case in chief. All right, Neama, we've talked a little bit already about the demeanor of the defendant, but equally important in my mind is the demeanor of the attorneys, because the jury is having to listen to them and hear their tone and watch their different body language. What is your assessment thus far of the prosecutor as well as the defense attorney as they've been questioning this witness?
Actually, so far so good. I particularly like the prosecutor's speed and pace. This is a judge that likes to move quickly. I think we're in federal court. I mean, we got a jury in a day, opening statements day 2, certainly much faster than we're seeing in other very high-profile trials like Derek Chauvin and the McMichaels and Ahmaud Arbery right now. So again, very quick, both in terms of jury selection and the pace of the questioning for the first witness. And I also liked how he wove in those themes. So lawlessness or law abidingness is an important theme in this case. I mean, that's certainly what the defense is arguing here. So the fact that Rittenhouse's own mom wanted him to flee the jurisdiction, even though Kyle did not, that is an important point that the prosecution brought out during Black's direct testimony. Again, the defense came back, and I like what the defense did, rebutted many of those arguments as well, did a great job during cross-examination. So I like what both attorneys are doing here so far, both in direct and cross, and not wasting the jurors' time. We're moving very quickly here.
As to the chaos, he did say there was a lot of violence. The crowd was pushing back. They were upset. They were throwing things. There was no safe place to be. But he also stated he didn't feel like it was necessary to exercise any deadly force in these circumstances. Granted, he was on the roof, not in the crowds. How does that weigh into the equation of this proof that the state must provide beyond a reasonable doubt?
Yeah, we got a little bit of veiled argument during that opening statement. I thought it was very effective when the prosecution is talking about the hundreds of other people, none of which used deadly force. Nor did Rittenhouse's own best friend, self-proclaimed brother, use deadly force when he was being attacked by rocks. So we know this is a difficult case, and I applaud the prosecution for bringing it. And it's difficult for a couple of reasons. The first is, and they both relate to Wisconsin law. The first is, under Wisconsin law, the prosecution must prove a lack of self-defense beyond a reasonable doubt. It's not a burden-shifting state there in Wisconsin, which is very important. So that's a difficult threshold for the prosecution. The other, which we haven't talked about yet, is Wisconsin actually also has an imperfect self-defense law. So obviously perfect self-defense, if Rittenhouse's belief was reasonable, it's a complete defense to the murder charges. But even if his belief was unreasonable, but he subjectively believed it, that would reduce the murder down to manslaughter there in Wisconsin. So very difficult case for the prosecution, a righteous case, but a difficult one, and I like how they're handling it so far.
Be found guilty if the jury makes that decision beyond a reasonable doubt of the lesser included charges. Just speak to that briefly, if you would, Neama.
It's always a concern when you're the prosecutor. What do? Do you add these lesser included? Because you may risk a compromise verdict. But I think it was the prudent course in a case like this. Because again, even though 2 people died, 1 was seriously injured, this is a tough case. And you know the case was going to go to trial from the jump, in terms of how the defense attorneys handled it, and the fact that you may get an outright acquittal if the jury buys this self-defense argument. So I like what the prosecution did, even though they're risking not getting convictions on those top counts, those first-degree murder counts, and getting a compromised verdict on manslaughter, because the last thing you want is for someone like Kyle Rittenhouse to walk entirely or just be hit with those weapons charges.
The pictures that throughout the opening the defense chose to show, and you do have a man with a skateboard, you do have, and they show where somebody's attempting, it looks like, to kick Kyle Rittenhouse, and that goes to the argument of self-defense.
This is why
well, it certainly does help the argument of self-defense.
Oops, I'm sorry. Wait, I'm so sorry. I should have said. Let me start with Wendy, if I could, please. And then Neama, go ahead. And I'm sorry. Now we're out of time because I kept talking. Neama, your last thoughts in the last 10 seconds.
Last 10 seconds is, I agree with the difficulty of the other 2 victims with a skateboard, one of which had a handgun. That's why the prosecution is focused on that first victim, Rosenbaum. I can use victim, even though the other attorneys can't.
All right. Thank you so much, Neama Rahmani, for joining us today. We always appreciate all of your expert analysis here on Court TV.